I think the structured settlement secondary market is in trouble. It's not that they're not making money. Okay, so from that standard, perhaps you could say they're doing just fine. But a couple of different court decisions, particularly in Illinois, in a case by the name of Brunston, some information that we have independently sought out in a couple of jurisdictions in Florida, which suggests that there's forum shopping going on, suggests that perhaps all is not as rosy as it seems. In another instance, on June 28, 2013, the CEO of a Maryland structured settlement factoring organization admitted under oath in a lawsuit deposition that he had fabricated multiple identities that were used in social media on the internet that was visible to consumers. Facebook, Google+, Manta, LinkedIn. The LinkedIn was a joke. The LinkedIn had these multiple personalities endorsing each other. I mean, how ridiculous is that? How misleading is that? And this is going on, and the question that's raised is, if this guy's doing it, who else is doing it? You have companies that are advertising through anonymous domain registrations. Then you have companies whose only posted address on their website and marketing materials is what amounts to a UPS mailbox or a mailbox at some office center, when the operations of the company are actually taking place somewhere else in the United States, or perhaps even outside of the United States. Now, in 2001, the Victims of Terrorism Tax Relief Act of 2001 was executed, and it went into effect in January of 2002. The Internal Revenue Code Section 5891, which was part of that legislation, provides certain guidelines to be followed, or mandates certain guidelines to be followed in order to avoid a onerous 40% excise tax on the settlement discount to be levied upon the settlement purchaser. One also has to comply with the local state structured settlement protection acts as well. The question is, are these acts being followed? And it seems to be that there's some either gray areas or there's areas where they're not being followed and it's just under the radar. Well, I think it's time that some of these things move onto the radar of Congress and the senators who passed 5891, because they need to know what abuses are going on in the structured settlement secondary market. All is not rosy. That doesn't mean that every single company out there is a bad actor, okay? But there's enough evidence out there, if one were to do a full-scale investigation, one would see that there's a lot of abuse. And for the IRS, who has a 40% excise tax, if you were to go and audit every single factoring company that's out there and determine whether or not there was, whether these transactions were done legitimately or whether there was forum shopping, you might find a great source of revenue. 40% excise tax on perhaps millions and millions of dollars, perhaps on thousands and thousands of transactions. One hopes it's not a lot, but the fact of the matter is, you know, just in a little bit of, with a little bit of research, we were able to uncover, you know, at least 2 or 3 situations. And one of our sources tells us that the reason why the IRS is not getting it is because they don't necessarily know what they should be looking for. And somebody needs to get with the regulators and understand these transactions in ways in which things are either being covered up or are not being done properly, and there's a source of revenue for the federal government. Now listen, I'm not trying to, you know, I have friends in the structured settlement secondary market that I talk to and I respect, and I think that they're knowledgeable. But it's clear that the industry itself is looking at itself. There are people that do things in an honest way that are looking at other people who are doing things in a not honest way and saying, hey, what you're doing is affecting us because there's this publicity about it. And so you take Robin Shapiro from Novation Capital, for example, did a presentation at the NASP meeting, which is the meeting of the National Association of Settlement Purchasers. this year, and he asked these type of questions of his own industry. Okay, so you have an insider asking questions of people in his own industry, and Robin Shapiro is not alone. There are people that I talk to who ask these very same questions. So the question I have is, if a trade association is not, and an industry is not able to regulate itself, is it time for the federal government or state governments or attorneys general to start taking a look at some, and the IRS to start looking at some of these things and start shaping things up? It seems really incongruous that we have regulations that create annuities and regulations for financial advisors and other types of financial transactions, regulations that target seniors, that protect seniors and are supposed to protect, people like the disabled, but this is a particular gap in regulation that needs to be closed. I've been writing and talking about it for 8 years. Why is nobody doing it? All it does is it arches the eyebrow and say, what is happening? What is happening in Washington that nobody is it that people aren't aware of it? Or is there cronyism? Is there somebody out there that's got a crony in Washington who's making big contributions? And I'd like to think that that's not the case. But something needs to be done. People need to be aware of this. So we've got this whole thing about possibly not complying with 5891 and Structured Settlement Protection Acts. But what about court scraping? What about privacy issues? You enter into a structured settlement transaction or a financial transaction, you've got the Gramm-Leach-Bliley Act, you've got HIPAA privacy laws, and yet if you buy a structured settlement, if you enter into a structured settlement, and it's a structured settlement that goes on the court record. Not everyone does. A lot of them are private transactions, but you have a case that requires court approval, has a court record. What ends up happening is you can surely bet that within a short period of time you're going to be contacted by someone from the structured settlement secondary market. Now, are they doing anything wrong? They're going to say they're not doing anything wrong, and they're just being innovative in terms of how they get information. There are list brokers out there that can supply you with information of potential prospects for virtually every type of business. But in the case of structured settlements, do the claimants, there's situations where people don't want to have things made public. So what steps are being taken to protect those people? And that's possibly something that needs some discussion and possible reform. The other aspects that need to be taken care of is how these things are advertised. Okay, and the terms that people use to market structured settlement secondary products. Now, when I talk about the structured settlement secondary market, I'm talking about people who purchase people's annuities and purchase people's structured settlement payment rights. In some cases, those payment rights are then aggregated and then securitized in the securities markets. In other cases, the structured settlement payment rights are assigned to individual investors. And that's the subject I'd like to touch on right now. There are companies out there that are marketing structured settlement payment rights as annuities. Now, they're not annuities. Okay? They are structured settlement payment rights. And that term is defined under the Internal Revenue Code. You're not buying an annuity. You're not the applicant for the annuity. I would submit to you that you probably don't have as clear statutory protections that you would if you actually purchased an annuity. And therefore, why are these people and these companies marketing them as annuities? I think it's misleading. I think you'll find if you were to look at these companies on the internet through the state insurance department in the state where you happen to be residing and considering this product, you'll find more than likely that these companies are not licensed. Okay, and if they are licensed, then good for them, but it's still not an annuity. So how can you call it an annuity? It's completely misleading in my opinion. And I think that some regulation needs to be had to prevent such companies from mischaracterizing these things as annuities. Now, it looks and smells and feels like an annuity because the payment rights are diverted or acquired and the checks that you receive are coming from an insurance company, but again, it's still not an annuity. You have to really look at it carefully and speak to a qualified financial advisor who can properly give you the advice. Now that brings me on to the next topic. There are people that are out there in the structured settlement secondary market who have little to no financial qualifications that are giving financial advice. Now, if they are a CFP or a CHFC, they're registered as a financial advisor with the SEC, that's one thing. But there are people out there that do not have the requisite qualifications that are calling themselves financial advisors. They're dispensing financial advice. They're helping people make life-impacting decisions with no qualifications. And whether or not they have good intentions, the fact of the matter is that there's potential harm that can come to American consumers as a result of this gap in regulation. I think it's important that people who are acting or are actors in this market, that they get with the program. I think it's important that regulators who are made aware of this and sanction people if they're acting as financial advisors when they're not. People need to be made examples of in order for this behavior to stop, because the lack of regulation is what's causing this dissonance in the structured settlement secondary market. Now again, I'm not saying that everybody in the structured settlement secondary market is a bad actor. What I'm saying is, because of the lack of regulation, these behaviors exist, they continue to exist, and people are encouraged by the lack of regulation to continue proliferating these bad business practices. So I leave you with this. I hope that, that this video podcast motivates some people to make some changes, and motivates regulators in Washington to sit up and take notice, for state attorney generals to sit up and take notice, and to finally make some changes and enforce the laws that are on the books. Thank you. I'm John Derer, Structured Settlement Watchdog. Have a great day.